us out of the LA jurisdiction. He's the public defender there, which means he tries a lot of cases. Philip Dubé, you have to poll the jury, especially if you don't like the verdict, because you never know. And I've seen it happen. Thank goodness not in one of my cases. But I've seen it happen where one of the jurors goes, that's not my verdict. And it's just like the courtroom will erupt in pandemonium. Polling is when each juror is asked individually in the courtroom as they're in the box, the jury box, one after the next. Is this your, like, Mr. Dubé, juror number one, is this your verdict? Was this your verdict in the jury room? Is it still your verdict? They're typically asked those three, or semblances of those three questions. And I have actually seen in real time a lady juror start crying, her lips started, and she said, it's not my verdict. So the judge said, okay, back in the jury deliberation room. About an hour later, they all came back, and it was her verdict by then. And there's nothing wrong with that. You can have a wavering mind or undecided or hung up on some point, but that's why you poll the jury, Dubé.
Of course it is. And once in a while, you do get one or two during that process who have what I call the unreasonable doubt. In other words, they kind of have buyer's remorse. They see everybody in the gallery anxiously awaiting whether or not this is your verdict. And now you're seeing truly the effect of your verdict. And before you deliver it, you need to make darn sure. But sometimes they got to go back into that jury room just to console that person and remind them, you did not have a reasonable doubt before we voted in the jury room. So which is it? Do you have reasonable doubt or not? And if they don't, they can stand their ground, and you know what? That juror can hang it. And if it's hung, so be it. And then you can give them the Allen charge. In Indiana, by the way, they don't do that dynamite or Allen charge. They abrogated it by judicial fiat several years ago. Instead, they just reread all the jury instructions because the court really has no way of knowing if they're hung due to intransigence or a misunderstanding of the law or some other ground. So they read everything and they go back so that there's no coercive effect of the judge reading everything to them, specifically that Allen charge. And yes, I have seen it, and I've also seen it in the civil context as well.
When Philip Dubé is describing an Allen charge, when we say a name like that, we're talking about a case. There was an individual named Allen. And in that case, the jury was out for a very long time, and the judge gave them what I call dynamite. And that is, the judge brings the jury in, all the lawyers are there, they put it on the record, and the judge says, it's your duty to go deliberate and reach your verdict. Now get back in there. That's what a dynamite charge is. So in this case, he's right. In Indiana, what the judge does is, instead of dynamite, they reread the jury charges again. Hint, hint. Go deliberate. So I think it has the same effect. But long story short, this is what happened. Listen.